Good afternoon, everyone. Welcome to our weekly COVID webinar. This week, an Ask Us Anything session. I'm Jackie Godapur-Werns, and I'm excited to welcome you today. With me are the Frantic COVID team members you've come to know and trust, Shelly Anderson.
Hi, everybody.
Nikki Baser.
Hi, everyone.
Dana Fattori-Crumley.
Hi.
And Jennifer Smith.
Hello.
Before we get started, for some light housekeeping, please submit your questions through the Q&A function on Zoom. It is much easier for us to keep track of questions there than in the chat. And also, please mark your calendar for next week's webinar, Biden's Back, Labor, Employment, and Education Law in 2021 and Beyond. Please watch your email for registration details if you haven't already registered for that great webinar. And as always, if you have any follow-up questions that you would like to discuss, or if we don't get to any of your questions, you can always contact any one of us or any other forensic attorney for questions. And please check out our website at frantic.com to find all of our alerts, webinars, podcasts, and other material on a wide range of school law issues. Okay, let's jump in. So we had a question during registration about the CDC's recent recommendation that individuals can quarantine for less than 14 days despite being in close contact. Nikki, can you remind us what the CDC guidance recommended?
I would love to, Jackie. So what the CDC came out and said was that as an alternative to the 14-day quarantine for those who have come in close contact with someone with a positive COVID test, you can quarantine for 10 days without testing if no symptoms have been reported during that quarantine time. Or in the alternative, you can quarantine for 7 days and end after 7 days if you have a negative test result. And again, there were no symptoms during that 7-day quarantine. So shortening the quarantine time potentially to 10 days or even to 7, half of the previous quarantine period.
All right, and then we all know then the IDPH came out with a response to the CD recommendation, about which we had a number of questions. Shelly, what did the IDPH say?
Well, I think you probably all saw it. The IDPH came out with kind of a one-pager talking about, the beginning of it is all about what the CDC changes. And then in the middle of it, it says, however, we recommend that you continue with the 14-day quarantine period because we think it is safer. They then tweeted a little chart that I'm sure you all saw that talked about 14 days is safest. Then there's 10, then there's 7, but they still recommend 14. So I think that in terms of the questions that we've got, both in terms of registration as well as in our practice, is what do we do now as a school district? Do we maintain the 14, 10, 7? And I think that you really have to look at your aversion to risk and how much the board is willing to look at this and say, what are the things that we put in place that we feel that the 7 and 10 days can continue to maintain the safety in the building. And I think that because it came out as a recommendation to continue the 14 from IDPH as opposed to a mandate, that schools can do that. They should just be in discussion with their council and the administration with the board as to what that could look like and what that could mean, but it could certainly make things a whole lot different when you're talking about kind of quarantining close contacts and you're trying to have schools open.
Yeah, and I mean, again, the significance of this is pretty major as far as operations because a lot of what we're hearing is the lack of staffing or the inconsistencies with having whole classes quarantine for long periods of time. So it really would be quite significant if you can go from 14 to 7. I mean, the thing that jumps out at me is that when all this started, a lot of boards and administrators committed to sort of following IDPH recommendations, and that's where they kind of planted their flag. So I do think this, even though it's not legally mandatory, it just makes it very hard. It would require a lot of communication and collaboration with those, with the teachers and everybody to really adopt to that 7-day approach in light of what IDPH is saying, I think.
And then Jackie, a question that just came in on this subject that we received relates to, what is the quarantine period? And the question specifically was, if you have a parent who's positive, how long does the child who's in close contact with that parent? I see that as different than what we're talking about is if you have a close contact, for instance, somewhere outside of your home. If you have a close contact in your home, unless you can keep those two people actually physically apart, you are continuing to be a close contact of that person. So I think then we have to kind of look at prior guidance in terms of how long you have to quarantine beyond that person's time period in which they can expose another person. So I don't think that this change from the CDC, even if you were looking to implement it, impacts if you are a close contact in the home, unless of course you can really maintain your distance between the two, which as parents, we all know with a child can be, quite difficult at times, so.
Yes,
Yeah.
we don't know, you don't know how people are living necessarily. You don't know what the makeup of their home so I would just agree with Shelley there and stick with the old guidance, just because I think that's a more equitable way to handle it.
Yeah,
given the unknowns.
I think so as well. And I wanted to circle back to something you said earlier, Shelley, in response is, looking at, what the other, if you're making a decision as a district, let's say we're talking about not a parent, but we're talking about, say, a close contact in the school building or outside the home, and you're deciding between that 14 days, 10-day/7, you talked about looking at what are the other safety protocols that a district has in place. And certainly if you are doing regular testing, that may impact, I would think. It also seems to me that one of the pieces of information that a district would looking at is what is the transmission rate going on in their school and in their community, right? And if they're seeing a huge uptick, then maybe they're going with the more conservative approach, the IDPH approach, and certainly to Jennifer's point, if that's where they've sort of stuck their guidance, that's what they're following. But if you're seeing low transmission rates in your community, low transmission rates within your schools, you're doing regular testing, it may be prudent to think about a shorter period. I don't know if you'd agree with that.
Yeah, I would. And that's kind of what I meant by other safety measures. So for instance, if you are able to maintain social distancing, even if it's not 6 feet, but you're able to kind of generally maintain social distancing, you're having good mask compliance, definitely if you're doing testing, because that puts you kind of in a whole other category of being able to monitor, even if you're just doing testing for clinical suspicion of COVID, not necessarily diagnostic. Then I think, look, we all want kids back in school, and this is a way to get kids and teachers back sooner. I would just be mindful of how else you're making sure that it's safe for them to come back.
So another big topic of discussion we got a lot of questions about during the registration process was regarding the FFCRA and whether we're going to see any type of extension. So Nikki, do you have any updates on that and how to handle communication to staff about the emergency sick leave days and childcare leave potentially going away on January 1st?
Right. I mean, at this point, we're not seeing any indication that there will be an extension for the FFCRA. And obviously, again, just to revisit for those of you who are still sort of in the mix on this, we have, as part of the FFCRA, the 10 days of emergency sick leave that folks can use. Particularly, this comes up when you need to quarantine, right? So what leave are teachers or staff taking? And then there's the extended EFMLA that folks can take for childcare purposes. So I know Shelley has some thoughts on how to navigate through this, but the advice that I've been giving and discussions with districts is you got to get out and start communicating on this now. If you haven't already done so, you have to. And we're going to talk. I know Shelley's going to talk about the labor implications of this, but there has to be communication about what's going to happen with leave. Specifically, what's going to happen when the district in particular requires folks to quarantine, or if folks have to quarantine because for some other reason, and what are you doing with staff who have been out because of childcare reasons and are going to continue to have childcare concerns even after the expiration of the FFCRA. Shelley, I don't know if you want to jump in on the bargaining and the employment issues there.
Yeah, and I think what we're seeing now, and I think I touched on this a bit last week, is now that the many people who've taken the childcare leave have either used up their 12 weeks or you've already quarantined for 10 days, kind of how do you handle this? And many districts that we work with who entered into MOUs did address this. I have very few districts I work with, however, that addressed what would happen at the conclusion of the current status. So it concluded December 31st. So what we're seeing now Are unions coming forward and making demands to bargain? What will happen moving forward? So how will we handle someone who has to quarantine, but either they never used up their 10 days or it's no longer available, how to handle that, and whether or not they have to, for instance, use their own sick leave, whether there's going to be some sort of sick bank available to those people to use that leave, whether they have to go on an unpaid leave. I mean, there are all sorts of options available, but we have to, look at it and think, well, yes, for quarantine, that would be something that would qualify for sick leave, but the union is likely going to want to have some conversation about if you're the one, you, the district, are imposing the quarantine because of potential exposure at school, do the staff members have to use their own benefit time for that, or can something else be worked out? And I think certainly how they handle that is very different if you're in a hybrid environment or a fully remote environment as to how you walk through that very difficult decision with your staff. And it might be different with teachers and support staff. It does not necessarily have to be the same depending upon what work you could have them do remotely, and what agreements you come to if you have two separate unions. So
yeah, I've already seen, I think that's absolutely right, and definitely in line with what I'm seeing so far. I know we've already worked out at least one MOU with unions related to sick bank, and so they've had the, it's nice to have a sick bank sometimes, because in this case, they were able to designate a certain number of sick days within the sick bank that could be used for COVID leave once the FFCRA either was, the individual staff person or teacher employee had exhausted their own emergency sick leave, or the FFCRA went away. So I think that's a that's a great solution. If you have a sick bank, it can work out well. I know you and I have talked to Shelley about districts who have granted additional leave, so 10 days of leave time, but have included in their agreements with the union to that the staff person has to use one or two or some number of their own quarantine sick days before they get those extra days, sort of to get some skin in the game, if you will, so people aren't just very few staff members we know are going to claim improperly that they need leave, but just to catch those who are abusing the system, that you have to have a little bit of skin in the game. So I do think that there are a number of options that folks can create with their unions, but I think now is the time, because you need to start communicating that this is going to start affecting everybody come January, especially those districts that are returning for the first time in January or February, and these issues are going to start to come up. I think the childcare issue can be even more complicated, because, and you really want to give your staff lead time if they have been relying on that EFMLA. Again, most of them may have exhausted it already, or it obviously will go away as of December 31st. And so I do think, making sure that they have lead time to figure out what they're doing with their children. I know some districts have allowed, we've heard them referred to in a variety of ways, Zoom rooms or other kinds of childcare options for school-age children of staff members to bring them into school. And I know I've written a couple of permission/waiver forms for those kinds of programs. And, some districts think that's a great idea. Others really don't want to go near it. I think, it's certainly an option. But again, giving just staff that heads up, this is what we're offering, or we're not offering anything, is going to be super important right now.
If I could add one more thing that I wanted to say about the quarantine piece, is that why I think it's so important that you have these discussions is because if you have, for instance, our support staff at many districts, in terms of the leave available to them, if they have to use their own benefit time, you do not want to do anything to incentivize people to be dishonest about whether or not they are symptomatic at all. So when they're filling out their self-certification form, you don't want someone weighing, well, I kind of don't feel good, but I don't want to say that because I may have to quarantine for 7, 10, or 14 days, depending on the circumstance. You certainly don't want that in your building. So making sure that you're weighing those things when you're looking at the answer as well.
And just to follow up on what Nikki said, I think originally we had questions about if we do a daycare alternative, if we facilitate that, then can we require teachers to come in person because we've solved their childcare, and that was not under the law. We couldn't, that law still applied. They still could take the leave, given childcare. But now I think that, like you said, that this might be a point to revisit, because if that leave isn't available and you're just helping facilitate the logistics so that, and they don't actually, the teacher actually doesn't have another good option, it might be time to revisit that kind of, it is more of a solution now, I think, than it was before, because you could not mandate it well, you're still not mandating it, but it's like either you can work and have a job, or, you know, and you do have a childcare option.
Okay, so let's pivot slightly and talk about staff on leave due to reasonable accommodations related to disability. What is the status of those requests?
So I think this was, it kind of goes along the same, times are changing, you know, as far as where we were at the beginning of the year is not where we are now. And so whereas districts might have been quite loose in whether they called them accommodations or just people didn't feel comfortable coming in, maybe due to a condition, but we didn't go through the full ADA interactive process. Now I think boards are putting a lot of pressure on administrators to get staff in the buildings and be really precise and only give leave or accommodations when it's actually legally required. So we're getting questions about revisiting some of those, and you know, also the situation is changing. We know more about COVID and spread. You know more about locally and your particular specific mitigation measures and how well those were working. So it's a moving target. And so I think, you know, again, we're getting, what are you ladies seeing as far as questions about revisiting accommodations at this point?
Well, I can get us started. I think this is happening everywhere. For any district that initially said that people could work from home or work remotely when the kids were remote, and some even did it even though they were in hybrid. What I'm seeing a lot of right now are unions pushing back to say, you allowed this accommodation in the beginning of the year, therefore you need to do it continuing and now. And certainly this idea of what is and is not a reasonable accommodation, and Nikki and I have been talking a lot about this as of late, because the unions are looking at it from the analysis of, you know, having someone else in the classroom while the teacher is remote is not an undue hardship on the district. And we've concluded that that's not actually the proper analysis, that it's really whether or not having someone work from home in and of itself is a reasonable accommodation. And if you can't supervise, you know, and that's an essential function of the job because you're home, can you actually perform the essential functions of the job? But I'll let Nikki just to talk about, you know, this gets tricky when you do allow some people to have that accommodation to work from home, but you can't allow certainly all teachers to do so.
Right, and just to sort of trace us back to the legal analysis here, as Shelley was talking about, which is that, you know, there was a couple of buckets of employees that we talked about in terms of accommodation, right? We talked about really the true accommodation requests, which were when folks were asking for their own health conditions. And those likely will continue now. And obviously the vaccines, you know, should they become more widely available or widely available at all to teachers, are going to potentially change that analysis. But for folks who, because of their own health conditions, requested and were granted accommodations, likely those will continue if you return. And it may be that if you're full in person, you can no longer allow someone to work from home and they actually have to take leave. And so that conversation that we had as districts started to go back would continue. I think the other bucket is those folks, as Jen said, there was a lot of flexibility and districts allowed folks to stay home because of members of their household, their illnesses or their conditions. And I think, again, I don't want to even use the word accommodation, right? Because under the ADA, you're not required to accommodate someone because of the health condition of a family member. So they were granted the flexibility to work from home, and those are really going to have to be, you know, you're going to have to look really closely at those again. And a lot of districts I know did start to pull back and are going to start to pull back, and that's again a conversation with the union. But ultimately the district does have the ability to say, look, if this is based on the health of your family member, we don't have to grant this accommodation. So it feels like these questions keep coming in waves as we, you know, as districts go in and out of hybrid, remote, they're on pause, they're coming back. And I think the key again is to be clear internally at your district how you are addressing these. And I know Shelley was raising the particular point of, let's say you do have a number of students that are still remote. So you do have a number of teachers who can work remotely, and you do grant as an accommodation that sort of remote teaching position. If you only have 20 of those and you have 30 requests, then you're not going to be able to grant that accommodation, and some of those teachers may end up having to take leave. And so making sure you've locked down your internal practice and policy on how you were working through those, and making sure that you're also communicating clearly with the union how you're doing that. And again, just because someone was granted an accommodation at one point doesn't necessarily mean that it continues to be a reasonable accommodation as schools return to in-person learning.
And just a final sort of note on that, I think it's really important to be proactive and think about when you're planning to bring kids back and plan ahead of time, because, as Nikki and Shelley have both mentioned, in the beginning, we weren't really granting accommodations, but we were being flexible because we had the luxury to be flexible in some cases because we were in mostly remote instruction. But the reasonable accommodation process, as we all know, because we hear complaints about it all the time from clients, can be a time-consuming process. So for the people that really are going to need reasonable accommodation, and you're going to have to work that through with them, you're going to need to leave yourself time before you need people back in the building to let that process take place. So just get a jump start on that.
So we also received questions about education funding. So I'm actually going to read from a question that we received. Any update on a possible second round of federal COVID relief funding for schools, and any word on what we might expect for a lame duck general session for Illinois? And if we will encounter any mid-year state funding budget cuts this year, or cuts for state funding next year. So just a little question, Nikki, not much there, right? Can you tackle that one for us?
I mean, I can tackle it by saying I think it's a real unknown. I hate to say that because we do pride ourselves on trying to provide some answers here. I think, there's a variety of different federal relief pieces of legislation that are on the table. I have not seen any great strides in terms of education funding. We may start to see some changes. And obviously into the new year, I think much is going to be dependent on what happens in Georgia, to be frank, in terms of what we see legislatively coming out of the federal government. In terms of the state government, again, that I think, again, an unknown in terms of funding. Obviously we all are, paying attention to the revenue projections. I would certainly encourage folks to reach out to their legislators as well, to their membership organizations like LEND and EdRed and all of those groups to make sure that this is front and center as on the General Assembly's plate. I haven't heard anything about mid-year cuts at this point, so knock on wood that we don't see that. But these are obviously concerning times, so I would encourage folks to stay in touch with their members of the General Assembly. Don't you love how lawyers can say we don't know in a really long way?
I don't know. I think that was great advice, Nikki. So I think that was a good answer. Jennifer, this one might be a little bit more concrete. Do we have any more updates on special education decisions on in-person instruction that you can tell us about?
Oh, yes. Just a short answer. Yes, we do. I had one case where we have a decision that from a hearing officer. So before I had reported, we've heard from ISB through a number of state decisions where they said in-person instruction or not is not a violation of FAPE, just not offering in-person, the safety decision. And I now know of the first, there might be others, but that I know of, a first Illinois hearing officer decision to say, will not just dismiss a case outright, do not have to have a due process hearing, just on a motion to dismiss a claim that seeks in-person, because that's not in the jurisdiction of hearing officers. So that really is a good, that's what our team had been advising that we thought should happen, but I hadn't actually seen that happen. And so I was always a little nervous. Sometimes our hearing officers can sometimes make decisions I would not agree with. So this was, I think, a good development that I'm getting more and more comfortable. Obviously, someone could appeal to federal court. This isn't the final word on it, on a hearing officer is not the final word, but I'm feeling more and more comfortable that that is the correct legal analysis. The modality of in-person or not is not something you can challenge versus through IDEA.
Right, but I think one thing to be mindful of is that this is a great decision for right now, and I think it's a good foundation. But for parents that seek attorneys, they're going to find a way to around this. You know, they're not going to make the claim on that basis. They're going to make the claim on the basis that the student is not making progress, and they're going to bring that issue in sort of through the back door, and that'll help them bring the complaint forward and take the complaint. And so really it is still very critical that even if you are in remote, to keep up with people, to track progress, to find things that you can and do with the student, to be engaging. And it is still requiring a lot of work and follow-up and, you know, contact with parents.
Yeah, I mean, I agree. It's the failure to implement claims and the failure to make progress, even in light of the implementation of the IEP, that is worrisome, especially as time passes. I mean, you can always hold IEPs and try something new, but I think the facts that I'm hearing out there sometimes are really, complete disengagement, won't get on remote, hasn't been on remote for months and months, hasn't engaged with any staff person. And now that we're hearing more and more, I'm hearing of the therapeutic day schools also going remote. Some of those more vulnerable students are really, really struggling, with that pivot that we're having now. So I'm just kind of hoping and holding my breath that, come January 11th, some of those high needs students can get back, and maybe we can just make, I feel like everyone's somewhat tolerant of, okay, there's not a lot we can do before the holiday in a way. I mean, there's only so much, but come January, I think we're going to have to get back to that problem solving mode, definitely.
Absolutely. And something is better than nothing. Even districts that are looking at bringing kids in for appointments and, just having some structure to the week for the most vulnerable students, just that alone can, it not the same as starting up school full time, but it can really be a strong defense to this type of claim.
Mm-hmm.
Well, if we didn't achieve anything this year, I will think that we have all grown in our vocabulary. So I know for myself, I had never heard or thought of a CLIA waiver, but many of our registrants are thinking about CLIA waivers. And so that is a certificate that allows a testing facility to perform COVID-19 testing. Nikki, let's talk about the legal issues that schools and districts should be thinking about when it comes to those CLIA waivers.
Sure, and I just want to start by giving a shout out to Victor Simon at Gower, who did a whole hour-long webinar on this for IASA. So some of the folks on this may have attended that, and I'm sure that IASA recorded that, and it's worth watching. He was sort of out in front of a lot of this and really gave a lot of really great information. What I will say is, this is particularly districts are looking at this now in connection with the BINEX test, which the federal government and the state are making available to a number of different entities, including school districts. And so the first step, if you want to be a test site for BINEX testing, is to fill out your CLIA application and create a program. And what I'll just say about the program from a legal perspective is that there's just a lot of components to it. It's just one of those things where you have to hit the check boxes. And so what you want to make sure of after you get your application filled out and submitted is that you are creating a program that has all of those components to it. There's components related to everything from, which locations are you doing it at? How are you disposing of waste? What are the confidentiality issues? What are the consent issues? What are the reporting issues in terms of test results? So, we're happy to help. We're happy to walk you through. We've got some form documents to get districts started if they're interested, and then can work you through getting all these components in place. It's just one of those things where you just got to hit the boxes, right? You got to check all the boxes. So, obviously, as we alluded to earlier, testing for districts who are able to implement testing programs, it becomes a little bit of a different ballgame in terms of getting students back and getting staff back, because it's just another tool in your arsenal to make sure that you are keeping schools safe, that you're giving a lot of peace of mind to both staff and students, and you're monitoring community spread, so you do know if there needs to be a pivot to remote, or you can maintain your in-person learning. So again, happy to help with CLIA waivers. I am too have learned more things about CLIA waivers and testing in the past couple of weeks, and I won't say it's exciting, but it is definitely a great development in terms of keeping schools safe. Or maybe it's exciting. I don't know. Who am I to say?
It's okay to be excited by stuff like that, Nikki. It's fun.
Thanks.
So speaking of keeping schools safe, let's talk about mandatory testing. I know from a lot of the questions we received that schools are thinking about mandatory testing, and we specifically received a question about what legal issues people should be considering with respect to mandatory testing. So Jennifer, can you tell us your thoughts on that?
Sure, and this is not without complication, so I'm going to boil it down, but anyone making a decision, I just want to give a particular disclaimer here. We should probably give disclaimers more often. If you're making a decision on this issue, really do seek legal advice. Don't just watch the webinar, because this is complicated and you need to know what risks you are and are not taking. I think the bottom line is that we think there is legal authority to allow you to require in-person testing as a condition of, or require testing as a condition of in-person instruction. So not that you have to get it to be a student in the district, because remember, we're still offering remote. So the position would be a little more nuanced than if we went back 20 years. You're still going to offer instruction, but as a condition of in-person, which maybe is the same thing as mandatory testing, but I think some feel better to describe it that way. So we think there is authority. Why do we think there's authority? Basically, because the school code, all of our colleagues, Todd Faulkner, he's so knowledgeable about who's the boss of who, like what authority does the board have, or when was that authority removed? And so we took a really deep dive, and we think school boards do have maintained the authority they have for safety, for exercising control of the school, for exercising protecting the health of students to do this. So, but there are things you're going to need to do. I mean, I think you're going to need to offer a process if you do require a student to go to remote. What does that, the literal steps in communication, and how can the parent object to that? You're going to have to consider religious exemptions, and then just know that there are, it's not clear. We haven't had a pandemic for a long time. There's not well-developed case law, and so it's possible that this will be decided differently by a different authority at some point. But I mean, much like at the beginning, if I were to put where we feel on it, at the beginning we said we thought there was a valid idea claim on the due process, but we didn't know for sure, and now we're starting to get some decisions. I'm kind of about the same. I mean, I'm not going to be surprised if ultimately someone gets dinged for this, but I'd be a little surprised. I think the authority is pretty strong here. There's reason to consider doing this. You're not being crazy to consider this.
Yeah, and I think that, as I mentioned last week, I mean, there's also, you're talking about the students, Jen, on the personnel side of it. I think there's also authority to indicate that we have the ability to mandate testing for our employees. Obviously, there is going to be a bargaining implication there that all districts should be aware of before they do that. But this is hopefully going to be a way to make everyone feel more comfortable of being back in school. And when the overarching principle from governor on down, there's one principle that we've had, is that get the kids back in school, right? That this is a way to do that. So I think even if there was some sort of pushback on that we would ultimately find support in the ability to weighing in the balance, that it's better to have this as a precautionary measure than it is to not do it and potentially impact someone's rights that way. So, and again, as you said, we've not had a pandemic, I think, since smallpox like this, which is I think where the case law comes from. So hopefully, all these measures will be taken into account if it's ever challenged anywhere.
And one of the other legal issues, which is a little bit tangential, but just wanted to raise, was just the legal implications of the actual physical testing itself. So I know there's been a lot of districts that are concerned, well, if we set up Binax testing, what if, I mean, with testing, it's unlikely that someone's going to get sick from being tested, but what if you test them and the test is inaccurate and then they sue you? And the good news on that front is that beyond tort immunity, which I think the Illinois Tort Immunity Act provides quite a bit of coverage for districts, in particular related to testing. If you follow the guidelines of the Federal PrEP Act, which is an act that essentially provides immunity when there is a health emergency like this and entities are taking countermeasures like testing, the immunity under the PrEP Act is quite broad. And so I think from a risk analysis in terms of the actual mechanics of testing and the implications of someone suing you over a bad test result or something that came from the testing, I think districts can sit fairly secure in terms of their immunity defenses for those kinds of claims.
All right, well, that's testing. Now let's talk about vaccines. I don't know if the rest of you have been listening as eagerly as I have to the news coming out of Britain about the beginning of vaccinations there. And so I know that people are already starting to think about mandating vaccines for staff and students. So we did get a question about what the consequences might be. Can we make getting the vaccine mandatory? What consequences can there be for those who refuse to get the vaccine? What do you do with that for staff and students? Nikki?
Sure, so I'll take students first. The student issue is an interesting one from a legal perspective. I think the same line of cases that Jennifer was citing to related to testing actually were really in the realm of vaccines. And so, it was clear at least at one point that a school board would have a fairly wide discretion to mandate vaccines for students. If there was a significant, if the outbreaks were of were significant, or there's a significant health risk in essence. What's interesting to me from a legal perspective, which, diving into the weeds, is that now we have a statute that those cases all predated section 27-8.1, which you all know and love as your immunization section of the school code. And that section basically says, you guys have to mandate all of the vaccines and immunizations and health exams that the Illinois Department of Public Health has set forth in regulation that you have to do. And there's actually a section in the IDPH regulations that literally lists out, you've got to get the MMR, you've got to get the polio, which ones and when. So I think there is a really interesting legal question as to whether, because there's a specific list, can a school board add to that list in essence, or do we have to wait for IDPH to do so? I think the good news, or it's also sort of a bad news, is that the approval for student vaccine or vaccines for children, I think by the time we get there, I'm going to guess that a lot of these questions are going to have been answered, or we're going to have a state mandate. And I know we're planning on reaching out to IDPH and saying, is this something you're looking at in terms of amending your regulations so it's clear students have to get the COVID vaccine? So I think on students, we can sort of hold for a moment on answering some of these questions just because we're not seeing a student vaccine on the near horizon. I think with employees, to be frank, we are still working through these issues. I think there is good authority to believe that we can mandate employees. I think this is an issue you're absolutely going to need to discuss with your union. There are significant bargaining implications. And I think the questions that were asked, Jackie, the one that you just read about what are the consequences, I think yes, what do the exemptions look like? All of those, I think, are the sort of devil's in the detail. And I know we are still grappling with those and we should have some answers soon, but I'm going to give the same caveat that Jen gave about testing and mandating testing, which is if you're going to mandate employee vaccines, you really got to get some work with your legal counsel, whether it's us, whether it's others, to really drill down and make sure that you are taking all the required steps and you're giving the required exemptions and the like. So again, we think we can get to a place where mandating vaccines for staff is an outcome, still working through some of the other legal issues involved.
All right, let's talk about travel. We just made it through the Thanksgiving holiday. We're headed into the winter holidays. Can a district tell a parent or employee that if they travel during these holiday periods to certain locations, that they have to quarantine when they return? And what legal issues do they need to think about? Dana?
So this was a big issue when we were working on getting everybody back to school. And I know districts sort of fell into one of two areas, the people that were coming back. You know, there was a lot of communication to families in the beginning of the year that if you do travel, you need to tell us and you are going to be moved to remote. And for the most part, you know, that I think there may be some legal challenges to that, because again, you're telling them that they have to do something and you might have to give some due process before you do that. And just saying that you're going to do it in advance may not be sufficient. But I think for the most part, in many places, that did work. And I think the places where we didn't get a lot of pushback were places where people did. There was a lot of parent education. There was a lot of outreach, like, listen, we're trying to give you what you want, parent community. You all have to work with us. You know, the problem with just saying you must, though, is then you have the people that want to sneak around and go to Disney World or wherever they're going in the pandemic and come back. And so that sort of created problems, is that then it would come out and people lied about it. And what do we do? You know, obviously a less stringent approach would be to say we recommend this and try to work through with families and use the other sort of quarantine procedures, you know, to bring people back. And at this point, as Shelley pointed out, the only place you can go that doesn't require quarantine is Vermont. So I guess skiing.
That was the last time I checked. I think you can still go to Vermont without quarantine based on our map. I think it was the only one that was not read by IDPH, but I could be wrong. I haven't checked.
All right, so it's too late for the fall colors, but you could possibly go skiing in Vermont and not be required to quarantine. As far as staff, you know, I think staff, you can set some parameters for and have some accommodate it, because obviously whether you are going to, you know, Florida for pleasure or for a baseball tournament is different than traveling because a relative is sick or something of that nature. But you know, these are all things that, you know, can we force people to do these things? We can give it a college try, but like there's going to be challenges that we're probably going to have to accommodate along the way.
Yeah, I think one thing to also remember about the employee piece is that, you know, we still have quite a few employees across the districts that we work with who want to work from home, right? They want to work remotely. So the idea of saying, if you travel, we're going to force a 14-day quarantine really does not help anyone in that situation. So just being really mindful of how you're walking into this and how you're handling it, and you're being consistent and all of that is, I think, really important as well.
Such a great point. And I wonder, poor Vermont, if they're going to be flooded with visitors for the holidays. Oh, my internet appears to be unstable.
You want me to jump in, Jackie?
I think I'm back. I'm
Okay.
back. I'm sorry. I want to make for the 150th time the joke about the internet not being the only thing that's unstable in this house, but I know that one's been used a lot. We did get an interesting question in the Q&A that I might slip in here now, that can employees use COVID sick days for days that a doctor makes them quarantine before a procedure or surgery? Nikki, you want to take that one?
Yeah, I mean, I would say yes to that. I'd be interested to see if anybody has any contrary. So we've actually gotten this more for our pregnant staff folks who have had to quarantine in advance of delivery, and likewise for surgery. If a doctor is requiring someone to quarantine, they would be eligible for emergency sick leave under the FFCRA, obviously up into December 31st.
I would agree with that.
Okay, so our next question is about self-certification forms. How do you deal with families who may stretch the truth or even lie on self-certification forms, or maybe just not do them? What do you do, Shelley, about that situation?
Well, this has actually come in from a few different districts that I work with. Is, how do you handle it if a child is coming in and saying, I have a stomach ache, or I have a headache, or perhaps has a fever. And I think that you need to be mindful of how you're back communicating with those parents, because, as we all know, just because the child has a headache when they get to school doesn't necessarily mean they had one when they were leaving for school. So certainly not accusing the parents of lying and being intentionally untruthful. We are all on this panel parents of young kids, and pre-COVID, I'm not going to say I did not send Charlie ever to school with a slight fever or with some Tylenol to get the fever down. I think now, hopefully, people are not doing that as much because of, obviously, the consequences are much different than they were years ago. But in terms of, if you find, my response has been to be, if you're seeing a consistent pattern of a parent who's either not filling out the certification forms, or the child clearly doesn't appear well day after day, that's different than the one-offs of a belief that the parent might not be being truthful on the form. If you know for certain that they are, so for those districts who are asking, have you traveled, right? And the parent says no, and then the teacher sees on Facebook the family was in Disney World, that's different. And maybe taking some steps there to say, you must now be remote for a week or two and provide all the self-certification forms for going forward, but making sure you're being upfront with families as to what those consequences will be, not just imposing them unilaterally after the fact.
Yeah, because there's sort of a principle, you don't punish a student for the sins of the parent, and courts really hold to that. So if we essentially expel, so especially if you're not offering a remote option that a student can slide into, which is the case for a lot of these in person, you can't just for 7 days go to the remote. It's you're just missing. I worry about that because that's essentially a suspension. And it's like, because parent, we want you to start behaving, not because remember, you can always screen, your staff can screen at the door. If actually, if just talking out loud, I think that's the better consequence, is slow down the entry point for this. We don't trust this parent. We know not to trust Jennifer Smith, if whatever. So we're going to make little Audrey Smith get her temperature checked at the door every day. That, I think, is the better solution than the effective suspension.
Yeah, and to be clear, my answer, I don't work with any districts that don't have an ability to slide into, and I know, Jen, you do, but mine was very much not that they would not be getting any sort of instruction, but they would be switched over to a remote platform for some period of time. And again, I agree, not penalizing the child for the parent being dishonest, but just doing something to make sure everyone is safe in the building.
Yeah.
So we know so many of us want to put our kids in the buildings, and then we want to be at home to work from home. So what about staff that aren't being truthful about themselves because they want to work remotely? Any thoughts on that?
Well, that's something similar to what I was saying about the quarantine piece, right? So, I mean, you have people who, it's on both sides of it. You could have people not being truthful on self-certification because they don't have any benefit time and they don't want to be in the building and don't want to be losing pay. Alternatively, if you're offering a remote option, you have staff who could be being dishonest because they don't want to come in the building and they want to work from home. That is something I think that is a critical piece to work with your unions on, as to how you're going to handle that and how you can make the determination of what will happen, not the lying piece of it, but if you can't pass the certification, for instance, are they going to have to take benefit time, or is there going to be something else? Or if it happens, 2 times, is there going to be a different circumstance or consequence than if it happens just once? And really working through with your unions to try to see whatever we can do to kind of get people in the right place and thinking ahead, the long game, as opposed to just individually how you're going to handle each situation.
All right, we did get a special education question that was very interesting. If special education families are declining to participate in remote learning, what should related services providers do about providing their IEP minutes, especially with a therapeutic day school setting? What does this look like, Dana, for all of the various aspects of special education?
So, I mean, if this question is coming in from a person that works at a therapeutic day school, I think the answer is a little bit different than if the question is coming in from a person who works in a public school. So obviously the public school is the LEA for responsibility purposes, which is the local education agency, and they're the ones on the hook for giving those minutes. So as the therapeutic day school provider, if you know that a parent or a student is not being present for minutes, the first thing you need to do is call the LEA, call your representative at the public school that's placed the day student, the student there in your day school, and make sure that that LEA is knows, because they're at great risk of liability. And that's important, I think, to your relationship. I know for therapeutic day schools, they're a very important part of the continuum of placement options. And we want that relationship, you know, between the therapeutic day school and the public school to remain strong and intact. And the therapeutic day school meets its obligation to the public school by keeping them really in the loop on these things. I think from the public school perspective, we really need to set an IEP meeting and then document that this is what is happening. I don't think it needs to be quite to the level of a prior written notice letter, which is basically like, by not doing this, this is the consequence. But I do think you need to let parents know that you are providing these services. It is their choice to not avail their student of the services. And there's not going to be time later, you know, you are choosing not to take it. It's not going to be offered. It's not like we're offering 5 sessions of, you know, basket weaving, and if you miss the first one, you can come to these 5 later ones. That's not how it's going to work. So you need to be very clear on that point. Jen, do you have anything else? It's unfortunate because I think people need to be taking the services that we're offering, but I know it's difficult.
Yeah, I mean, just practical. I think this is happening a lot for our more severely disabled group. I have parents that are like, this, it's not worth it, or even it's such a negative reaction in the home when they tried it that they're just exhausted. They're not going to do it anymore, and no amount of telling them to do it is good, you know. Right. So I do think documenting that and coming before you stop making it available, though, like, so there's, you should continually make it available, check in, even if the parents told you no, still don't reassign that staff member and have it not be available, because now it gets murky. Are they not getting it because you don't have it available, or because they said once and you're like, it would be hard to prove. So you actually need a meeting, I think, like Dana said, with the documented that the parent is absolutely refusing service. I mean, if it wasn't the pandemic, I would say, you know, they need to revoke consent or drop out, or they're true, depending on the age of the student, they might be truant, you know. I think we need to be a little careful about that right now, and maybe just have a sequence of meetings and see how things go, especially if we expect an in-person option, you know, in a few months, maybe. I wouldn't be too harsh with, you know, I'm calling the truancy officer, but that's what it is, you know. Yeah. So if we're talking a real little kid, you know, an 18-year-old's different than a kindergartner in this situation too.
Yeah, and I also think the thing that I recommend that teams, when they have that initial meeting, you should offer and make available parent service. So parent training is a related service under IDEA, and we almost never offer it, almost never. Like under normal circumstances, it's not something that's on every IEP. But I think when you have the very disabled kids or the little kids that, you know, teachers do have tricks of the trade, like, okay, we're going to have our snack before we have math, even something as simple as that. Having a teacher that's used to working with that particular population of student, whether it be a very disabled student, a very young child, to talk to the parent for 5 or 10 minutes, put it on a service of the IEP, that's another way to really defend yourself if the parent claims later. And it can make a difference. I think the parents probably are discouraged. It's not, we all know from having kids, it is much easier. Like, you don't know the right way to do it. This is not the way the teacher said to do it. How many people have had that conversation? And then the kid slams the door in your face or something else delightful. So to sort of reach out to the parent and make them feel heard, I think will help you practically and legally.
Yeah, sometimes, I mean, not to go on and on, but sometimes the question I ask is, well, tell me what that looks like in your home. So, and because sometimes I get, well, I don't know the term. I don't know why they're doing it. I'm like, I don't want to know why. I just literally want to know, do they not even get out? Do they not get out of bed? Is that what the problem is? Or they sit in front of the computer and they get frustrated, and then what is actually going on? Because that might give you some tips as to, is this something we can problem solve, or are we totally, we actually agree with the parent, this is really not going to happen.
All right, we got a couple of questions in the Q&A. So one is, if families have recently moved during the pandemic and are in a different country or state, are we still obligated to have them enrolled in the district? Nikki.
Sure. Well, I'm going to just start with the gen ed, and maybe maybe Jen or Dana can jump in on the special ed, because I think there's a slightly different potential analysis, although likely you want to treat all your students the same. If someone has moved mid-school year, they have a right to remain within your district for the remainder of the school year. And so obviously, if you guys, to the extent that you're remote, I mean, some folks have just left for temporarily and they still maintain their residence, their primary residence. We know, Jackie, you've been a little bit of a nomad for various reasons, but you maintain your primary residence in Chicago. And so for those students, absolutely, they remain enrolled because their primary residence is your district. For those who have actually officially sort of moved their main residence somewhere else to another state or another country, they can continue for the remainder of the school year. Now, obviously, the hope at some point is that we are all going back in person. And if that happens, they would actually have to physically attend your school, or they would have to, disenroll and then re-enroll in wherever they're located. I think that the analysis is similar with special ed, Jen, but I know that there is some issue about who's ultimately responsible for paying for services and who's responsible for providing a FAPE that make it a little bit different.
Right. Under the school code, special ed residency does change when mid-year. There might be different arguments that can be made, but that's important because the LEA should change technically. So that's when you might want to reach out on, because it does, especially if it's a costly private placement, or there's a lot of reasons that, and just for consistency, you may want to enforce and require that the other LEA take over at that point.
Okay, our final question. Can we tell non-union members that they cannot travel out of state? Shelley, thoughts on that one?
Well, I think this is a tricky one in terms of telling them they can't travel. If we're talking about non-union members, these are probably at-will employees that we're talking about. So the terms and conditions kind of are determined by the employer just as they're the employee. So one, I would say, telling them they can't travel is not the answer. Telling them the consequences of traveling is the answer. So to say, if you travel, you will not be permitted to work, will be docked for 14 days, or you'll have to take some sort of benefit time afterward. I think that is more likely the answer. But before you even get there, I think you should really think about why you're doing this. Because I think just the idea of traveling, we were talking about this when we were prepping, and going outside of Illinois is not necessarily the problem, because you could have people engaging in really risky behavior who are in Illinois versus someone who's just traveling to Wisconsin to escape and quarantine somewhere else safely, for instance. So I think I'd be really careful about making sure you're understanding the why behind what you're doing, as opposed to just implementing something that says all these people have to quarantine. You may be left without the staff to do what you need to do upon coming back to from break, for instance. And I've gotten that question quite a few times.
All right, everyone, that is all the time that we have. So as I mentioned, next week, we're going to be having a really exciting webinar addressing what is to come in the Biden administration in labor, employment, and education. And then if you've checked your calendars, you will note that the next 2 Thursdays after that are both holidays. So we will see you back in January after the break for more on COVID. And until then, please continue to send your questions to us at covid@frantic.com, and please take care. Thank you to all the panelists.
Bye, everyone.